Imagine it's a quiet afternoon in Abuja. The kind of afternoon where the only sound you expect are the hum of generators and the distant laughter of children. But on February 19th, 2026, on a serene street called Mambilla Close, off Aso Drive, that peace was shattered. It happened around 2 p.m. If you've ever been in Wusi, you know that area. It's usually quiet, reserved. But on this day, a convoy of operatives pulled up outside house number 12. Before we go any further, I need you to think about something. When does an official search warrant cross the line into what feels like an invasion? This is the question at the heart of a 1 billion naira lawsuit that has just been filed. If you care about the balance between law enforcement and personal liberty, hit that like button and subscribe. This is a story that concerns every single Nigerian. Let's set the scene. Mambilla Street isn't a place where you expect drama. It's an unassuming street in the highbrow Aso Drive area, home to diplomats, politicians, and business people. The security is usually tight, the streets are quiet. But on that Thursday afternoon, the silence was broken by the arrival of operatives from the Independent Corrupt Practices Commission, ICPC, accompanied by police officers. They came to the home of Mallam Nasir El-Rufai, the immediate past governor of Kaduna State. According to court documents later filed by his legal team, the officers entered the premises and conducted a search. But here's where the story gets complicated. They were acting on a warrant, but what kind of warrant was it? Now, at this point, we need to look closely at that piece of paper. The former governor's lead counsel, Oluwole Iyamu, SAN, took one look at the warrant and, in his professional opinion, saw a document riddled with problems. He would later describe it to the Federal High Court as defective. He pointed out that it lacked specificity, meaning it didn't clearly state what items the officers were supposed to be looking for. It had typographical errors. There were mistakes in the address, the date, and even the district details.
However, you should imagine that you are at home, maybe with your family, and armed officials walk in. They start going through your things, they pick up your personal documents, your electronic devices, phones, laptops, tablets. These aren't just items. They are the archives of your life, family photos, private correspondence, years of work. And as they take them, they don't leave behind a receipt. They don't provide an inventory. You are left watching your life's records disappear into government bags with no paper trail. What would that feel like? The legal team described it as causing significant psychological trauma, humiliation, distress, and emotional harm. The very next day, February 20, the machinery of justice began to turn. El-Rufai's lawyers moved swiftly, filing a fundamental rights enforcement suit at the Federal High Court in Abuja. The case number is FHC/ABG/CS/345/2026. Now, who is on the other side of this case? It isn't just the ICPC, though they are the first respondent. The suit also names the Chief Magistrate of the Magistrates Court of the FCT, the Inspector General of Police, and the Attorney General of the Federation. This is significant. By including the Chief Magistrate, the suit is directly challenging the validity of the judicial process that issued the warrant in the first place. By including the IGP, they are addressing the police officers who participated. And by including the AGF, they are putting the entire federal government on notice. The core argument is simple but powerful. The search warrant was null and void. Why? Because according to the lawyers, it violated specific sections of the Administration of Criminal Justice Act 2015, particularly sections 143 to 148. These sections require that a warrant be specific, that it describes the items to be seized, and that it is based on probable cause. Iyamu SAN argued that the warrant failed these tests. He pointed out that the vague wording meant it was essentially a general warrant, the kind that gives officers the power to look for anything and everything, which the law frowns upon. He cited landmark cases like COP versus Omo and Fawehimi versus IGP to support the principle that evidence obtained through an improper warrant is inadmissible.
This is where the numbers become staggering. The former governor is not just asking for the return of his property or a declaration that his rights were violated. He is seeking 1 billion naira in damages. Let's break that down because it tells us how his team views the severity of the incident. 300 million naira is being claimed as compensatory damages for the psychological trauma and emotional distress. 400 million naira is sought as exemplary damages. This is the part designed to send a message. It is meant to deter law enforcement agencies from future misconduct. 300 million naira is for aggravated damages, reflecting what they describe as the malicious, high-handed, and oppressive nature of the operation.
And finally, 100 million naira is requested to cover the legal costs of this high-profile litigation. Another angle to this issue is the timing. This search didn't happen in isolation. It was the latest in a series of legal and security actions involving the former governor. Just days before the search, El-Rufai had voluntarily honored an invitation from the Economic and Financial Crimes Commission, EFFC. He was detained by the EFFC, and upon his release, he was immediately picked up by the ICPC at the EFFC's gate. There is also the airport incident. When he returned from Cairo on February 12th, there was a confrontation at the Nnamdi Azikiwe International Airport. Security operatives attempted to detain him, and his international passport was temporarily seized. And to top it all off, the Department of State Services, DSS, has filed cybercrime charges against him relating to comments made during a television interview about the National Security Advisor's phone being tapped. So, we have to ask ourselves, is this search a standalone event, or is it part of a wider, coordinated crackdown?
Now, let's step out of the courtroom and onto the streets of Abuja and Kaduna. The reaction has been a mix of concern, debate, and political maneuvering. Usman Okai Austin, a chieftain of the African Democratic Congress, ADC, the very party El-Rufai recently joined, publicly criticized the ICPC's approach. He praised the DSS for going to court with charges, calling that the civil and democratic way, while suggesting that the ICPC's detention tactics appear to place the agency above the law. He pointed out that detaining someone before completing an investigation is retrograde, undemocratic, and illegal. This raises a critical question for you, the viewer. In a democracy, who watches the watchmen? When the tools of the state, search warrants, detention orders are used, what safeguards exist to ensure they are not being used as weapons in a political or personal feud? From this point, we need to understand the political backdrop. El-Rufai is not just any former governor. He was a key figure in the APC, instrumental in President Bola Tinubu's emergence as the presidential candidate in 2023. However, after the election, his ministerial nomination was surprisingly not confirmed by the Senate. Since then, he has become a vocal critic of the administration he once helped build. He recently defected to the ADC, signaling a realignment of forces ahead of the 2027 elections. To many observers, the timing of these legal troubles feels more than coincidental. So, where does this leave us? The suit is filed. The court has yet to fix a date for the hearing. El-Rufai remains in the custody of the ICPC as of the time of this report, with his lawyers stating they have not received a response to their bail application, despite the constitutional 48-hour window for detention without charge having long expired.
The former governor is scheduled to be arraigned on the DSS charges on February 25th. The same day, his fundamental rights suit will be heard in the FCT High Court. It will be a pivotal day. The lesson here for the public is twofold. First, it is a reminder of your own rights. If officials come to your door with a warrant, you have the right to inspect it. You have the right to ensure it is specific. You have the right to demand an inventory of anything taken. These are not privileges, they are rights enshrined in the 1999 Constitution. Second, it is a lesson in communal responsibility. We must support anti-corruption agencies in their work. Corruption is a cancer that has held this nation back. But we must also demand that the cure is not worse than the disease. Due process is not a technicality to be bypassed. It is the shield that protects every citizen from arbitrary power. Before we wrap up, I need you to engage with this. Drop a comment below. Do you believe the ICPC overstepped its bounds? Or is this the pushback we expect from a powerful politician facing scrutiny? Let's get the conversation going. And if you believe in holding power to account, both political power and state power, please like this video and subscribe to the channel. We will be watching the courtroom on February 25th, and we will bring you the updates as soon as they happen. The story of House Number 12, Mambilla Street, is more than a story about one man and one agency. It is a story about the fragile line between security and liberty, between investigation and persecution. As we wait for the court's gavel to fall, one thing is certain: the outcome will send ripples far beyond Aso Drive. It will define for a generation how Nigeria balances the fight against corruption with the fight for individual freedom. Stay informed, stay engaged, and remember, the law is our common ground.